Your Honor, my name is Lee, initial P, and I appear for the defendant, Mr. Marshall Ike. Your Honor, we submit that Mr. Ike's admissions to the police should be excluded as evidence in the case against him. Your Honor, I have two submissions to make. Firstly, that Mr. Ike's admissions may be excluded due to the police acting improperly. That is, Mr. Ike's cultural background not being taken into account when the police were questioning him. And secondly, that the police did not fulfill their legal requirements before questioning Mr. Ike for an indictable offence. If it pleases Your Honor, I will begin with my first submission. Your Honor, we submit that Mr. Ike is a special person under Section 21A of the Queensland Evidence Act 1977, being a child of Torres Strait Islander descent. We submit that Mr. Ike's age and cultural background was not taken into account when determining whether a question is improper when he was questioned by police. On the day of the incident, police officers caught Mr. Ike after he was seen running away from a residence's driveway and proceeded to ask him a series of questions. Your Honor, we submit that the police officer did not take into account the language issues and cultural differences when questioning Mr. Ike, such as the use of slang and jargon and the avoidance of direct questions, lack of eye contact, silence, and most importantly, gratuitous concurrence. Gratuitous concurrence occurs when an Aboriginal or Torres Strait Islander person, such as Mr. Ike, agrees with a white person based on a cultural reluctance to displease because of cultural difference rather than because they actually agree. We submit that Mr. Ike admitted to the goods found in his backpack weren't his and that he broke into 84 properties was because of gratuitous concurrence rather than because Mr. Ike actually committed the crimes. We submit that the admission was obtained from Mr. Ike by a police officer acting improperly and should be excluded. I will now move on to my second and final submission. Applying Section 418, 420, and 421 of the Police Powers and Responsibilities Act 2010, police must inform Mr. Ike that he may telephone or speak to a friend, relative, and or a lawyer. Inform Mr. Ike that a representative of a legal aid organization would be notified, and allow Mr. Ike to speak to a support person chosen by Mr. Ike before questioning starts. Your Honor, we submit that Mr. Ike was not informed of his rights under Section 418. Also, that Section 420 is breached as Mr. Ike was not informed that a representative of a legal aid organization would be notified. Your Honor, Mr. Ike was only told by a police officer that a social worker would be his support person and that she would sit with him during the interview. We submit that of the few minutes that the social worker and Mr. Ike was in the room together, the social worker did not speak to Mr. Ike. Your Honor, we submit that a mere greeting from the social worker and the social worker asking Mr. Ike to respond to questions from the police and no verbal responses from Mr. Ike do not amount to speaking and, as such, a breach of Section 420. Moreover, we submit that Mr. Ike not being able to speak to a support person chosen by himself as a breach of Section 421. Your Honor, we submit that as a child under Section 21 of the Queensland Evidence Act, Mr. Ike did not understand that the interview was a serious matter and that he was giving evidence, as was in the case of R and BBR. Without a parent or guardian present, without a parent or guardian or a support person of Mr. Ike's present, Without a parent or guardian or a support present of Mr. Ike's choosing when the interview took place, we submit that the recorded interview should be excluded by public policy discretion because the police did not comply with their legal obligations in the case of Bunning v. Cross. We submit that allowing the recorded interview to be admitted into evidence would be prejudicial rather than probative. Your Honour, that concludes my submissions.